you for joining Reinhart Berner Van Duren for our webinar, Critical Developments in Commercial Real Estate Arising from COVID-19. Before we get started, I would like to run through a few housekeeping items for today's webinar. Today's slide presentation will advance automatically in sync with the live presentation. A printable version of the slide presentation can be downloaded from the webinar control panel in the handout section. Volume can be adjusted using the volume control on your computer or phone. Throughout the webinar, type your questions using the questions section in the webinar panel. We will answer as many questions as possible at the end of the presentation. This webinar provides general information about legal issues. It should not be construed as legal advice or a legal opinion. Attendees should seek legal counsel concerning specific factual situations confronting them. Today's panel of presenters are attorneys from Reinhart's real estate practice. And our first presenter is Rick Donner, who is a shareholder in Reinhart's real estate practice and a member of the firm's entitlements group and commercial leasing group. Rick?
Thanks, Nancy. Good afternoon, everyone. My name is Rick Donner. I'm a shareholder in Reinhart's real estate department. Thanks for joining us. I hope everyone is hanging in there in these difficult times. Clearly, the COVID-19 pandemic has impacted every aspect of our daily life, from where we work to when we can go shopping. This, of course, has a severe impact on the commercial real estate industry. My colleagues and I are going to discuss that impact by looking at three specific areas in the industry: landlord-tenant, real estate financing, and construction. We'll generally address some of the questions we've been getting from clients in these areas and discuss what we've been seeing in the marketplace. There should be some time at the end for questions, and out of respect for everyone's time, we'll attempt to end promptly at 3 p.m. We fielded many questions from our commercial landlord and tenant clients arising from the unusual circumstances presented by COVID-19 and the resulting impacts on the operations of their businesses and their leases, such as, can I withhold rent? Is the COVID-19 virus a force majeure event? Can I require my tenant to deep clean the premises after one of its employees tested positive for COVID-19? The answer to almost all the questions we've been getting is, it depends on what your lease says. While force majeure and related legal arguments may impact the parties' obligations under the lease, and we'll get into force majeure clauses specifically in a moment, the most likely result is the lease is still a legal and binding contract. That is true for the obligations of both tenants and landlords. Therefore, reviewing the lease needs to be the starting point of any analysis. For example, can a landlord obligate a tenant to do deep clean of its premises if one of the tenant's employees has contracted the virus? The starting point in the analysis is reviewing the lease to confirm it as language requiring the tenant to maintain its premises in good order and repair. That is typical commercial lease language and remains enforceable. We then look to what other language in the lease might be relevant, such as, does the lease contain language requiring tenants to take appropriate steps to ensure their business does not interfere with the landlord's operation of the building or other tenants' businesses? That could be another basis to insist on a tenant undertaking that responsibility. On the landlord side, the lease likely imposes upon the landlord obligations to maintain the common areas in good repair and in a way that ensures all tenants may enjoy the use and benefit of those areas. That remains enforceable and may require extra maintenance on the landlord's part during the pandemic. In all circumstances, answers to the questions raised by COVID-19 will be tied to what the lease says. Before we get into the legal details, I'll briefly touch on some issues we are currently seeing in the market. We've seen an immediate and material adverse impact on retail space, and a little less but still substantial impact on office and industrial. Landlords and tenants are both trying to figure out how to navigate these unique circumstances. The facts are changing rapidly, and the duration and the extent of the impacts are unknown. I was on a conference call in mid-March with a consultant in the restaurant industry who has a national client base. This was at the start of the period where circumstances appear to be changing daily. Restrictions to half capacity, to no more than 50 people, to being shut down completely. The consultant instructed its clients to not pay rent in April or for the foreseeable future, and to begin preparing for negotiations with landlords for rent deferral and rent abatement. The consultant's advice was based on the extreme change in circumstances suffered by these businesses and the practical realities of the market the consultant saw. But was it legally justifiable? Probably not. The lease remains a binding contract. Rent is legally owed when called for in the lease. However, right now, many commercial tenants appear to be holding off on paying rent as long as possible, given the state's temporary ban on evictions and the rapidly changing conditions on the ground. Landlords, understanding the circumstances and having an interest in their tenants emerging in financially strong position and hopefully ramping up quickly after this crisis abates, may be inclined to grant tenants some leeway on rent payments. However, landlords may be limited in their ability to do so. Loan documents often contain covenants that limit the landlord's authority to amend the lease or waive enforcement of its provisions absent lender consent. So without flexibility from its lender, the landlord's hands may be tied. Another consideration for landlords is what impact federal stimulus will have and how that might factor into the agreements they make with tenants. Much of the funding from the CARES Act will not go directly to landlords, but to tenants in the form of forgivable SBA loans. Theoretically, a portion of those funds will be used to cover the tenant's rent expenses. However, many details of the program remain to be worked out, and the timing for distribution of the funds is anyone's guess. Tenants have also looked to their insurance policies for relief, making loss of income or business interruption claims. The claims are based on their business operations ceasing as a result of the mandated closures due to the COVID-19 outbreak, and ask the insurance company to cover those losses. Unfortunately, direct physical loss is what triggers coverage under most commercial tenant insurance policies. And since COVID-19 claims do not involve a direct physical loss, insurance companies have successfully denied coverage. These policies also often contain exclusions due to viruses and government action. On March 31st, Wisconsin's Office of the Commissioner of Insurance upheld a denial of a similar claim in the state, stating in its letter to the insured that the insurance company demonstrated that they are following their policy terms. The Commissioner's Office also added, currently, there is no law requiring insurance companies to provide coverage for this type of claim related to the outbreak. If there should be a government mandate in the future, perhaps the claim could be revisited. At this time, however, we cannot compel them to overturn their decision. Interestingly, lawmakers in New Jersey, Ohio, and Massachusetts have proposed bills that would retroactively expand business interruption insurance policies to cover companies' losses to the outbreak of COVID-19. Unsurprisingly, the National Association of Mutual Insurance Companies called the proposal potentially disastrous and expressed concern that it constitutes an inappropriate intrusion into contract law. The last potential impact on the market I wanted to note is the effect working at home may have on the future need for space. We know of a transaction in the state where an office tenant was set to both renew its lease and expand the premises, but recently decided against both the expansion and the renewal after the initial success of its employees working remotely. Just one example, but potentially something to watch. Now, I'd like to pass the mic over to Brooklyn Kemp and Josh Taggett for a discussion of force majeure. Brooklyn?
Thanks, Rick. My name is Brooklyn Kemp. I'm an associate here at Reinhart, and I'll be discussing a little bit today about force majeure and the role it may play while we face this pandemic. So some may be questioning their ability or their counterparty's ability to meet certain contractual obligations due to the coronavirus pandemic or some related governmental action. And some of these questions are whether a tenant must keep paying rent or whether certain delays can be excused in performance. As the situation evolves day by day, the answer is not clear-cut, but a helpful place to start may be looking at the force majeure provision in your contract. Just a broad overview of what force majeure is. It's a clause that's present in a lot of commercial contracts, particularly leases. The provision excuses a party's performance of obligations under the contract for a certain period of time when certain events arise that are beyond the party's control, and these events make performance very difficult or impossible. The force majeure clause in your contract will typically include a list of events, commonly acts of God, famine, strikes, and sometimes epidemics or pandemics. Another thing to note is that force majeure is temporary. It only applies for the period of time that that event prevents performance, and some contracts will also specify a period of time that it will last. So one of the first steps in determining whether force majeure applies is reviewing your contract. Because whether a claim of force majeure will be successful is a very fact-intensive inquiry. It largely depends on the language of the particular provision as well as the circumstances of the affected party. Because the language of the provision will ultimately control when a force majeure has occurred, it's really important to review your contracts carefully and have your attorneys help to analyze and evaluate the provision's applicability. There are a couple key things to keep in mind in order to make a claim for force majeure event. The particular event, which would in this case be coronavirus or related governmental action, must fall within that list of events that are in the force majeure clause. For example, your clause might state that a pandemic is a force majeure event, which would be ideal. Even if pandemic is not specifically set forth in the list, many provisions will end the list with the catch-all phrase and any other clause outside the reasonable control of the affected party. This catch-all phrase would require a little bit more of an analysis to determine whether coronavirus or a governmental action would fall within it. Another thing to keep in mind is that the particular event, which again in this case, coronavirus or the related governmental action, must be a direct cause of the inability to perform obligations of the contract. So things like business closures or event cancellations because of the coronavirus could potentially help to establish a force majeure claim. If your contract doesn't have a force majeure provision, there is another doctrine that might apply called impracticability. It operates in a very similar manner to force majeure, although traditionally it is very difficult to claim, and the remedy is very different than it is for force majeure. Force majeure is for a specified period of time. It's temporary, whereas if you want to claim impracticability, the remedy is complete cancellation of the contract. This might not be a practical solution for those who want to keep their contract intact. Josh, do you have anything to add?
Yes, thanks, Brooklyn, and thanks, Rick. My name is Josh Taggett, and I'm a real estate litigator at Reinhart here in Madison. On the force majeure side, as Brooklyn mentioned, that is a lease provision, not to be confused with impracticability, which is a legal doctrine. So with force majeure, as Brooklyn mentioned, a major key is what the lease language actually says. There's two reasons why, in general, the force majeure provisions in commercial leases are unlikely to relieve a tenant of their rental obligation. The first is on the lease language side, which is that most or many commercial leases do contain language that will create an exception for the rent obligation from the force majeure provision. So in other words, a force majeure incident will expressly in the lease not relieve the tenant of their obligation to pay rent. Even in leases where that's not the case, one of the elements that courts typically require when a party is trying to utilize a force majeure provision is to demonstrate that alternate performance is impossible. And so that in many cases may apply for performance-based obligations that the tenant may have. A good example would be if they're required to remain open for certain hours of operation, that may be made impossible by COVID-19 and some of the related government orders. And so from that perspective, that may be something that a tenant would be relieved from. In the case of rent, it's rare that you would ever find it to be impossible for rent to be paid, practically speaking, courts are usually not going to concede to financial difficulties that the tenant may have and say, well, now it's impossible to pay rent. So for those reasons, it's unlikely that force majeure would apply. But obviously, it's something that's going to evolve over time. Given that we're in a different time than we've ever seen in the past, we could, as a result, see some different laws. So I think it's something for all of us to keep our eye on. On the impracticability side, again, that's a legal doctrine. It's not necessarily a lease provision. But as Brooklyn said, that also is unlikely to provide a tenant with relief from paying rent, in large part because impracticability typically applies when the purpose of the contract itself has been completely frustrated. And of course, if you have a 5 or 10-year lease and there's a limited use of the property for a month or two based on a governmental order, it's unlikely a court would view that as a complete frustration of the contract. A better example of where impracticability would typically apply would be if I were to contract with you, for example, to build a casino, and then a couple days later, the local government prevented casinos in that particular area. The entire purpose of the contract would be frustrated, and as Brooklyn said, the contract would be subject in that case to rescission, which means it just goes away completely. It's unlikely that courts would be willing to reform an existing lease based on an impracticability argument. Reform it, meaning relieve the tenant of the obligation to pay rent for a couple months during the middle of that lease term. So for all of those reasons, I think the takeaway on these topics, force majeure, impracticability, and any other similar provisions that you might see in a lease, if you're the landlord, is that they likely don't apply. We're not anticipating that most of them will apply. And you should get counsel involved if tenants are raising those provisions to make sure that you're responding to them timely and in the appropriate manner. If you are a struggling tenant and if you're trying to make the case for relief from rent, again, it's something that you'd want to get your counsel involved. You'd want to make sure that the lease provisions are reviewed in detail. And you'd also want to give consideration to how this COVID-19 pandemic has impacted you personally, your business personally as the tenant, because that could have an impact, particularly under the impracticability analysis. So I think those are the key takeaways on force majeure, impracticability, and again, any other provisions in the lease that might be similar. I think next we're going to go over to Justin Oath with comments on rent deferral strategies.
Thank you, Josh. My name is Justin Oath. I'm a shareholder here at Reinhart in our real estate department in Madison and specialize in commercial leasing and construction. So just so all of you know, this is the first time that I'm actually presenting via webinar. So please bear with me as I figure out this technology. I actually had a dream last night that all of my colleagues had abandoned me and went through the entire presentation by myself and forgot to unmute my button. So I'm checking all my controls here just to make sure I'm good to go. But from all of us at Reinhart, we do really appreciate you joining us. We understand that there's a lot of uncertainty in the world, especially in the real estate world as a result of this coronavirus crisis. And we hope that we can provide some degree of guidance here with respect to the issues that we're going to talk about. So I'm right now going to be talking about rent deferral strategies. And we just heard from Josh in Brooklyn that it is unlikely that a tenant has the right to unilaterally abate rent based upon a force majeure and impracticability argument. I've been asked by a number of landlords and tenants to take a look at their lease, and based upon the current situation, I've not been able to find a single instance where a tenant has the right to unilaterally abate rent under their lease terms. So the next question then becomes, as a tenant and my business is being squeezed and I just physically can't pay rent, am I able to work out a mutually acceptable arrangement with my landlord so that I can defer rent down the road to a time maybe when my business is operating at closer to full capacity. And I've talked with a number of landlords and tenants on this topic in recent weeks, and it's become even more of a pressing topic right now since we're a week into April, and April 1st was really the first time that rent has become due since the pandemic really has hit hard and Governor Evers' order has been issued. Um, but I'm going to be talking about first factors that should be considered by the parties in deciding whether or not to defer rent. If they are going to defer rent, how to document any agreement, and then finally, kind of what I'm seeing in the marketplace as to how rent deferral is being structured. So first, kind of just a handful of considerations that the parties should be considering as far as rent deferral. First of all, this is a case-by-case determination. I'm not seeing any landlords out there that are making blanket decisions that they're, not going to work with any tenant on a rent situation. Each property and each tenant of that property is different and brings about its own unique set of circumstances that have to be considered. For instance, Rick had mentioned, retail and restaurants and bars have been hit especially hard over, tenants that are in an office or industrial properties. National tenants are probably most likely going to be treated differently by a landlord than a local small business tenant will be. In this regard, I do think it is reasonable and appropriate for a landlord to ask to see proof of hardship and to require the tenant to show that it really is not able to pay rent. I've seen landlords ask to see financial statements now and throughout the entire deferral period. A second factor, and Rick had mentioned this too, I think everyone is familiar with the passing of the CARES Act, which includes stimulus for small businesses. I'm not going to get into details on that, but just know that there are payroll protection loans that are issued by the SBA that cover certain expenses of small businesses, including rent. Those loans then convert to a grant if certain covenants are met. So I've had some landlords say, hey, I'm not going to be a bank for this tenant. There's other resources out there that I, as a landlord, am not eligible for, and those tenants should be pursuing those resources. I've also seen other landlords say that are willing to work with a tenant on a rent deferral, that they're actually conditioning their rent deferral on having the tenant apply for these payroll protection loans and then agreeing to apply a certain percentage of those loans to rent if they are approved. Another factor, obviously most landlords have debt obligations on their properties, so a lender's flexibility on loan payments are obviously going to dictate how much rent the landlord's able to defer. So landlords need to be out there speaking with their lenders about whether a rent deferral will make sense. I know Nathan Wadier is going to speak shortly on what he's seen on the landlord side. And then finally, there is a state mandated moratorium on all evictions, and even in the commercial context. And Josh Tagetz is going to speak about this shortly. And I realize that most landlords in the current environment are not looking to kick their tenants out to the curb, but a tenant's likely going to be less willing to make rent payments or they're going to reprioritize their rent payments if they know that they're not going to be evicting. So this moratorium is really tying landlords' hands. And I think what we're seeing is landlords are more likely to engage in discussions on rent deferral since they can't pursue an eviction. So once the parties kind of go through these factors, the next question for landlords, well, what do I do? And then how do I document that? One option is for the landlord to do nothing. They don't have to. They're not legally obligated to grant a request for a rent deferral. And from a purely legal perspective, again, this is legal, and we understand there's other considerations like tenant relationships, but from a purely legal perspective, this may be the best option for the landlord. If the tenant fails to pay rent or doesn't pay all of it, while they can't evict the tenant or terminate the tenancy, the landlord can still send a notice letter and call the tenant in default under the lease. This gives the landlord more flexibility moving forward, and they can decide when and to what extent they can pursue other remedies under the lease. And again, that's just from a purely legal perspective. It's from a tenant relationship perspective. I'm seeing a lot of landlords willing to work with their tenants. And it's perfectly understandable that a landlord would want to preserve that relationship and agree to defer rent. In that case, I would just highly recommend putting any rent deferral in writing. Preferably using a law firm. Obviously, as some of you know, I've got strong ties to a very reputable law firm. Our attorneys are exceptional, good client service. So if you don't use our law firm, I would encourage you to use any other legal means. So the documentation I'm seeing are, you could do an amendment to the lease, especially if we're changing multiple provisions like extending terms. But what I'm seeing more often and in recommending to clients is a forbearance agreement. And this provides the landlord with some added protection in the event of a tenant bankruptcy. With the forbearance agreement, in essence, the parties are acknowledging that a default has occurred, that rent continues to be due and payable under the lease, and the landlord agrees not to pursue any remedies. Whereas under just a standard amendment, the parties are just agreeing to defer rent obligations to a future date. There's no default, and rent is due at a later time. This is an important distinction from a bankruptcy perspective. If the tenant were to file for bankruptcy after the deferral has been agreed to, and I'm not going to get into the specifics on the bankruptcy side of things, but the type of claim that the landlord has using a forbearance agreement has priority over other claims, and it's not subject. It's considered a pre-bankruptcy claim, and it's not subject to a cap if the lease is ultimately rejected in bankruptcy. So for this reason alone, the bankruptcy component, I'm seeing landlords prefer using this forbearance agreement type of document. So what am I seeing in terms of how rent deferral is structured? And I'm seeing a lot of creative and different scenarios. Probably the most common situation I'm seeing is having the rent deferred for a couple of months, 1 to 3 months, and then repaid shortly thereafter. So for instance, working with a landlord on a national tenant, deferred rent for 3 months, and then they agreed to pay a lump sum in September. I've also seen the repayment of the deferred rent over anywhere from a 3 to 12 month period. I'm seeing other things like terms are being extended. So if the rent is being deferred for 2 months, you add that termed at the end of the lease. And also, I've seen a situation where landlords are giving 1 to 2 months abatement now if the tenant agrees to extend the lease for 5 years. I'm also seeing some landlords dip into the tenant's security deposit and applying all or a portion of that to base rent. Just real quickly, there is one more strategy as well, and that's a lease buyout. A landlord may be in a situation where they're with a tenant, they want to mutually part ways for whatever reason, and just know that in these cases, any buyout or termination fee that's paid to a landlord is treated for tax purposes as capital gains and not as ordinary income as rent payments would be. So that's another thing to keep in mind if the parties want to negotiate a buyout. So I'm going to pass the baton back to Rick Donner.
Yes, thank you, Justin. Sorry, we're on mute. Well done. Hello, I'm Rick Donner. I'm a shareholder in the Milwaukee office. I'm going to talk a little bit about the government shutdown of business and possible eminent domain implications. So in an effort to slow down transmission of the virus and to keep our healthcare system from surging past capacity, federal, state, and local governments have essentially shut down businesses, either by requiring certain businesses to cease operations altogether or requiring citizens to stay home, except for urgent and necessary reasons. Now, how does that impact the building owner's rights? How does it impact the lease? The first question is in many ways the biggest issue that owners of business and retail space will face. What are your rights if the government essentially makes you shut down your building? The short answer is not much. The law makes a distinction between a government taking a piece of property for a public good, such as building a library, or to prevent a public harm. Government authorities are allowed to impose certain restrictions on the use of private property pursuant to the exercise of their police power. Police power is the inherent power of the government to promote the general welfare of the community, and it covers all matters having a reasonable relation to the protection of public health, safety, and welfare. The Wisconsin Supreme Court distinguishes an exercise of police power from an act of eminent domain as follows. The state takes property by eminent domain when it is useful to the public, and under police power when it is harmful. The property owner is due compensation when a taking is for a public good, while no compensation is paid when a taking occurs to prevent a public harm. For example, a shoreland zoning ordinance that prohibits the filling of a wetland and thereby restricts the property's development is not a compensable taking because it serves the public interest of protecting natural resources. On the other hand, the government taking your property to build a firehouse or expand a highway is for the public good and requires the owner to receive just compensation. It seems almost certain that the government's response to COVID-19 is a proper exercise of its police powers. Whether it's the state of Wisconsin or the city of Milwaukee, the government has the legal authority to impose restrictions on the use of property when done for the public good, especially when those restrictions are temporary in nature. I'd now like to pass it over to Mr. Taggett for a discussion on the status of evictions. Josh?
Thank you, Rick. Yeah, and again, my name is Josh Taggett. I'm a real estate litigator in Reinhart's Madison office. My primary focus with regard to evictions is the emergency order number 15 that the state of Wisconsin recently issued. There's two primary components to that order. One is foreclosures, the other is evictions. I'm going to focus primarily on evictions, but I'll just briefly note with regard to foreclosures that at this time, foreclosure proceedings are suspended. That also includes all sheriff sales, which are prohibited and suspended at this time. And so that, from that perspective, that is impacting all foreclosure proceedings as well. But to turn things over to the eviction side of things, as Justin mentioned earlier, the suspension on eviction proceedings at the moment applies both to residential and commercial evictions. And there was actual reasoning provided in emergency order number 15, given that there has been some skepticism of the prohibition on commercial evictions at this time. But nonetheless, that is in emergency order number 15, and it has been moving forward. So what does that mean for landlords right now? Number one, you can't file an eviction action, obviously. If you even tried to do that, courts wouldn't allow you to file it. Additionally, if you've already received an eviction judgment, or if you're in the process of getting an eviction judgment, you can't proceed with the eviction. You can't proceed with actually removing the tenant at this time. And that goes even if you have a writ of restitution. So even if you've gone through the eviction process and you've gotten your eviction judgment and you've got your writ of restitution, you're not allowed to serve the sheriff's department with that writ of restitution in order that they would execute upon it. So there's no way right now, regardless of whether rent's being paid or other defaults, to remove a tenant, whether they're residential or commercial. And the only exception to that is if there's issues related to health and safety of someone at the property, which applies in a very small subset of instances. And so I think the primary rule for landlords right now, particularly commercial landlords, is you can't kick anybody out. And to that point, you are also prohibited within emergency order number 15 from even issuing notices terminating the tenancy. So if rent is missed and you wanted to proceed with an eviction procedure, typically the first step would be to issue your notice of default. The notice of default would say that rent has not been paid, and if it's not paid in full within the next, say, 5 days, depending on what the cure period is in the lease, we'll be terminating the tenancy and proceeding with legal action. As Justin mentioned, if someone does miss rent, we would recommend issuing a notice of default, but now you have to ensure that you don't say anything about terminating a tenancy. You can't allude to the idea that the tenant would be forced to leave the property or vacate the property if rent is not paid. But in order to I think there's two reasons to get notices of default out that at least identify and put the tenant on notice of those defaults occurring, particularly in the case of missed rent. One is to demonstrate that those types of defaults are not going to be waived or otherwise tolerated by the landlord, again, unless there's a business reason to provide more leniency. But also, you want to ensure that you're documenting everything as appropriately as you can, and it could help you down the road when you're looking at, if corrections have not been made with respect to the missed rent down the road, it could put you in a better position if you notice those defaults right away when they originally occurred. One exception that I was somewhat surprised to see was, at least in Dane County, they are still allowing landlords or other plaintiffs to file rent and damages claims. So if you've already gone through the eviction process and if the tenant has actually been evicted, the next step in the process is any rent and damage claim, which is just a monetary claim. If the tenant has already vacated, they are allowing you to proceed with those rent and damages claims. So just a note in case you're kind of in the middle of an eviction proceeding between the eviction phase and the rent and damages phase, you may be able to still take some action that way. So I think also to echo what Justin said earlier, at this point, we're recommending landlords to stay, I guess I would say, on the aggressive side when rent is missed, making sure that you're getting defaults out unless there's some business reason or a tenant relationship reason why that doesn't make sense in this particular instance. And when requests are made for rent reduction or other types of relief, it's best to respond to those issues in writing. We do have some forms, some letters we've developed as these issues have come up that we can provide you with some assistance on if you're getting multiple requests from a variety of different tenants on rent relief. And then finally, just sort of a general note, obviously in this context, getting paid as soon as possible is always best. It kind of goes without saying. But working on the commercial eviction side, I can tell you that it's a lot more painful when we're having to take on eviction actions where the tenant has missed 6, 7, 8 months of rent before we are able to go ahead and process the eviction. It's a lot easier to get through, and usually things go much more smoothly if the eviction is occurring 1 or 2 months or even 3 months out from the original missed payment. That way, you're just not in the hole as much, and it's easier to turn the corner more quickly. And obviously, that becomes even more significant in a context like this, where there's a lot of uncertainty. So with that, I'm going to turn things over to Nathan Wadier with financing implications.
Thank you, Josh. I'm Nathan Wadier. I'm a shareholder in our Madison office, and I'll be providing a rundown of what we are seeing in the financial markets as they relate to commercial real estate. As Rick and Justin noted, this pandemic has begun a conversation between landlords and tenants, and it's also started conversations between our borrowers and our lenders. As Justin noted, all of these conversations need to be happen concurrently or risk creating defaults under existing loan documents. From a macro perspective, what we are experiencing in the financial markets is not the same as the Great Recession, as the current distress is not being caused by underlying real estate valuations or related fundamentals. The distress is also not the fault of any borrowers or lenders. What is happening now is happening quickly and is expected to end more quickly. Most credible economic predictions that we're seeing place the beginning of normalization in the commercial real estate markets somewhere between late second quarter and early to mid third quarter. As a result, what we're all trying to do is create sufficient cash flows to allow our businesses to survive in the interim. Also, unlike the Great Recession, and probably because of that experience, federal regulators have been very proactive in providing guidance to federally insured lenders and encouraging them to work in good faith with their borrowers. To that end, the federal regulators issued a letter to banks on March 22nd, encouraging banks to work with borrowers in good standing to, among other things, waive fees, provide payment deferrals of both principal and interest for up to 180 days, and extend payment terms. A key part of the guidance was an affirmative decision by the regulators to not classify these modifications as troubled debt restructurings or TDRs. Classifying a loan as a TDR requires lenders, among other negative consequences, to post additional equity reserves against such loans. By explicitly allowing banks to work with borrowers now and not be subject to such TDR requirements has resulted in banks proactively reaching out to borrowers in good standing to offer relief. This is all really good news for commercial real estate and will hopefully help our industry create sufficient cash flows to weather the storm. So what are we seeing in the Wisconsin market specifically? Based on actual deal flow and conversations with others in the industry, this is what I have to convey. Let's start with existing borrowers. Banks are reaching out proactively to modify loan terms. Modifications on existing debt include deferrals of interest, principal, and sometimes both for periods between 90 and 180 days, waivers of reserve payments, no fees on these modifications, extensions of maturity dates to match these deferral periods. And anecdotally, what I'm seeing is that the smaller and more local the bank, the more borrower-friendly the terms. As bank gets larger, I'm seeing additional terms added to the deferral agreements, such as limits on distributions, limits on reserve accounts, and requirements for borrowers to apply for SBA loans being offered as part of the CARES Act, and requirements to use proceeds of such loans to pay debt service. For borrowers with CMBS loans, there's really no good news. No debt service deferrals or loan extensions are being offered by servicers, and in most cases, the servicers don't have the authority to do so. At best, and assuming you can get the servicer to respond, borrowers are getting freezes on having to pay existing payments for reserve accounts and access to these existing reserve accounts to pay operating expenses. As an aside, and to emphasize my earlier comment about concurrent conversations, if you have CMBS debt, it's very important that you understand what's allowed under your loan documents. By way of example, you do not want to provide an accommodation to a tenant that will then trigger your non-recourse loan to become recourse. In regards to new loans, at the end of March, there was a 2-week panic that kind of stopped all deals and lenders were pressing pause on new approvals. That now seems to be abating, with most lender types willing to review and approve loans again for most asset classes. However, lag times on third-party diligence reports such as appraisals are slowing down the approval process. Rates are still quite low, in the low 3s to the low 4s, depending on the type of lender and the asset class. The asset class does matter. Retail and hospitality, as you can guess, is very hard to get done. Office and industrial are getting done, but generally need to be lower leverage with a strong borrower or tenant. Multifamily is normalizing the most, and many lenders are still actively looking for projects. Traditional banks are looking at loans again, but are being deliberate. Most life companies have come back into the market after the end of the March pause. Fannie Mae and Freddie Mac spreads have come back down, and deals are getting done in that sector as well, especially lower leverage deals. For leverage greater than 65%, Fannie and Freddie are requiring short-term pandemic-related reserves to be deposited at closing to backstop financial covenants, but these reserves are then going to be released after the pandemic. The most distressing news in the financial market is perhaps the collapse of the CMBS market. The CMBS market has stopped originating new loans as investors have stopped buying loans and are demanding prohibitive interest rates if they do buy them. Loan originators are getting crushed by demands to buy back defaulting loans or margin calls from their investors. Loan servicers are in a similar situation as defaults begin to rise. Both the loan originators and loan servicers are thus reducing their staff to free up cash flow in an attempt to weather their own storm. These layoffs are further complicating the position of existing borrowers with CMBS debt who are trying to get existing debt modified. Federal legislation will likely be needed in this area as well to help free up this market. Overall, though, the financial markets are still operating in the commercial real estate context. April rents, while not normal, appear to have come in better than expected for most sectors, and hopefully the conversations and agreements that will take place between borrowers and lenders in April will significantly soften any negative impacts that occur in May and June. Now I would like to pass the presentation on to Joya Sanders-Wodarchuk, who will discuss Wisconsin's Safer at Home order. Thank you.
Thanks, Nathan. So my name's Joya, and I'm an associate in our Madison office, and I'll be talking about the impacts on construction that the Safer at Home order has had. Specifically, I'll be focusing on the question of whether construction can continue, and if so, to what extent. So now, my short answer is that yes, construction can continue, but the real discussion lies under that second part of the question, to what extent? And most of the answer lies within Section 10 of Wisconsin's Safer at Home order. In Section 10, the order allows individuals to leave their residence to provide or maintain essential infrastructure. Now, essential infrastructure includes, but is not limited to, construction. So now the question is, what type of construction? And in the order, it specifically says that construction that is allowed includes construction for public health, hospital construction, long-term care and assisted living facilities, public works construction, school construction, essential business and operations construction, and then construction necessary for essential governmental functions, and lastly, housing construction. Now, I'm going to unpack those last three: the essential business and operations construction, the construction necessary for essential governmental functions, and lastly, housing construction. So for essential business construction, the order lays out in Section 13 what essential businesses are, what's included as an essential business. So those include our grocery stores, our supply manufacturers, etc. And so the essential infrastructure language allows construction to continue for, say, construction that is circulated around grocery stores or any of our essential businesses. Moving on to the essential government functions section, essential government functions is a little bit more broad in how it is defined. And so with essential government functions, it allows the government basically to decide what is considered an essential government function, including our highways and other public works. And then lastly, for housing construction, again, that is more broadly interpreted in the order and includes any multifamily and single family construction. However, it does accept out any remodeling or other optional or aesthetic construction work. Now, in section 10, it also gives us a little bit more of a broad scope, and that section ends by saying that essential infrastructure shall be construed broadly to avoid any impact to essential infrastructure and should be broadly defined. However, even with that, in a public statement that the Deputy Chief of Staff of Governor Evers has stated, she has made statements that noted a more narrow interpretation of the order and has cautioned businesses from using an overly broad interpretation. So yes, construction can continue, but we have to kind of pay attention and run this fine line between what's essential and what's not. So now I'm going to turn the mic over to Justin.
Thank you, Joya. And this is Justin Oath again, and I just wanted to kind of follow up on a couple of points from the Governor Evers Safer at Home order. Enforcement of the order is done at the local level. So if there are questions as to whether your project can continue or not, one strategy may be to follow up locally to see what your municipality has for plans of enforcement. I've also seen situations where you are able to get some clarification or ruling from the state as to whether a business or construction project constitutes an essential business or essential infrastructure. So I'm just going to kind of give you some general thoughts on the impact of the coronavirus on the construction industry and things that I'm seeing from my vantage point. The consensus in the industry is to expect delays and potentially increased costs. The key factors in that is the belief that the coronavirus will impact supply of materials, equipment, and the labor force. I'm also hearing of delays in getting on-site inspections and permits issued by governmental agencies. It's an evolving process. I actually just got an email about an hour ago that Governor Evers issued another executive order that impacts construction. So we're getting new information and things are evolving every day on this. So it's important to check out these executive orders and to see how they're impacting construction. I personally have only seen one client project where the construction's been delayed. And that was the result of certain materials that were being manufactured in China. All other projects that I'm a part of are moving forward as scheduled. I have heard and read of major projects that are indefinitely delayed. I know the Wisconsin Center expansion in Milwaukee is one of those delayed projects. Some cities, Boston, for example, out east, have even issued a citywide stop work order on all projects. And this has impacted roughly 100 projects overall and over 21 million square feet of new or renovated development. So I suspect we'll continue to see more examples of these types of delays until there's more certainty with the COVID-19 situation. As to those construction projects that are moving forward as part of Governor Evers' order, they are required to continue to comply to the extent possible with state DHS guidelines, which mimic those of the CDC regarding social distancing and sanitation measures. General contractors and not owners are contractually responsible for all safety measures on projects, as well as all of the means, methods, and techniques of construction. So I recommend to all general contractors that there should be implementing and enforcing specific coronavirus policies for all workers on a work site. And some examples of things that I'm seeing on work sites are putting more hand sanitizer stations and hand washing stations on site and requiring workers frequently wash their hands, social distancing as much as possible. I've seen where they're limiting to one subcontractor at a time at a site, or limiting it to one subcontractor per floor on a multi-floor project, allowing for frequent breaks, and making sure that all shared tools and equipment are washed. So while all of these measures are good practices, it does have the potential for project delays. And these types of things are occurring on work sites, along with supply chain disruptions and labor shortages. Those are the types of things that are likely to be the biggest impact on schedules. So how are delays then dealt with in construction contracts specifically? I'm going to talk just briefly from both the contractor's perspective and the owner's perspective. From the contractor's perspective, most construction contracts specify a date by which substantial completion must occur. Some even include fixed liquidated damages for each day of delay beyond that substantial completion date. And this brings up the issue of force majeure, and it's similar to those that are found in leases and the concepts that Brooklyn and Josh discussed earlier. If you recall, force majeure are certain events or conditions under which one party excused from performing for the duration of the day. And the two main factors that I see most in construction contract force majeure provisions are, one, that the condition was unforeseeable, and two, that the parties lacked control over the condition. So the types of construction contracts that I see the most are the AIA and the consensus documents. And the AIA document does not specifically cover coronavirus as a type of delay that permits extension. It talks about unusual delays in deliveries, other causes beyond contractor's control, and other causes that contractor asserts and that architect determines justified delay. The consensus document, on the other hand, specifically includes epidemics, so it clearly covers the COVID-19 crisis, whereas the AIA document does not, which I found interesting. Contractors that are intending to rely on a force majeure clause also must pay close attention to the notice provisions. In the AIA document, in the AIA contract, claims for additional time must be initiated within 21 days after the occurrence of the event giving rise to the claim. And then under the consensus documents, requires the contractor to provide prompt written notice after first recognizing the delay. And the consensus documents goes on to say that the contractor must take reasonable steps to mitigate the effects of the delay. So a contractor can't just sit back on its hands and say that they can't do anything. They actually have to be taking efforts to mitigate the effect of the delay. And then real quickly, I know we're short on time, what are the biggest impacts from the owner's perspective? And as stated before, the coronavirus crisis is bringing about a lot of uncertainty and changing circumstances that may make an owner uneasy about continuing the project. There are two clauses in most construction contracts that may be helpful in controlling this situation. One is a suspension clause, and the second is a termination for convenience. So suspension clause, which is found in both the AIA and consensus document, allows the owners to temporarily suspend the project for a short period of time for any reason. Again, you've got to give notice. And under the consensus document, just a quick point on that. You got to give notice, but if it's suspended for more than 60 days, the contractor has a right to terminate the contract. So just be careful of that. And then in addition to the right of suspension, owners also have the right under most construction contracts to terminate for convenience. If that happens, the contractor has to stop work, mobilize the project, and terminate all subcontracts and purchase orders. So that concludes my portion of the presentation, and I see we're right up at 3 o'clock. So I'm going to punt this back to Rick and Nancy to see if there's any time for questions or not.
Hello, everyone. This is Rick Donner. Yep, thank you very much for attending. I'm sorry, we did run out of time here. We do want to stop promptly at 3 to respect everyone's time. We'll look at the questions and attempt to circle back to people by email if we can. So we appreciate everybody for joining us, and please give us a call or contact us, attorney at Reinhart if you got any follow-up questions. Thanks.